Earlier this year, when the Enforcement Directorate had issued summons to two very respected senior advocates of the Supreme Court of India, the entire legal community was shocked. One of them was senior advocate Arvind Datar. Well, the public outrage and the hue and cry led to the Supreme Court of India to step in suo motu to lay down limits on the investigative overreach over summoning lawyers in cases. Today, we have senior advocate Datar with us to understand the implications of this particular judgment, not only on the privilege of the attorney-client relationships, etc., but also on the independence of the legal profession. Thank you so much, Senior Advocate Datar, for being with us in the Parliament Ventures interview series. So, just to start off with the question is that the court has, in this particular judgment, called the probe agencies to have probably, violated certain statutory mandates, either by abject ignorance or deliberate design. So my question is, given the tendency of the agencies, in particular, what led to this particular case, was it right in not choosing to lay down the formal guidelines that everyone was expecting it to do so while summoning advocates, etc.?
Well, I did see the judgment, and they have declined to lay guidelines, as in the case of Jacob Matthew or Vishaka. But I think in the last paragraph, the Supreme Court has issued directions. Now, you may call it guidelines, you may not call it directions. It's a matter of words. But I do think that they have laid down directions, and they have specifically said we are laying down directions in the last paragraph, and then follows with 7, 8 directions, which I think are in the nature of guidelines because they are pointing out they have included safeguards which are not strictly in the act. So to that extent, I would say the court has issued directions slash guidelines.
Right. So what are your views on, the extraneous means being used by the investigating agencies often to stretch trials? Whether it be filing supplementary charge sheet over the years or introducing additional, witnesses and evidences at the 11th hour when the trial is about to be completed, etc. My question is, does this really justify the entire phraseology that process becomes punishment?
Well, yeah, that is, I think there is no better truism than process is the punishment. The very thought of going through, and in the meanwhile, the man is in jail, he doesn't get bail. It's virtually impossible to get bail. We have seen in very many high profile cases, people are arrested, and after 7 years, 6 years, they are acquitted. And who's to compensate for the lost time, lost name, prestige, and so on. But yes, there is a serious problem on that. And partly, I think it's because, see, I'm not a criminal lawyer, so I can't speak with that much authority on that subject. But from what I've seen in the PMLA Act, the definition of money laundering is so wide, the proceeds of crime is so wide that sometimes there's nothing to do with crime, there's nothing to do with proceeds, yet you become within the purview of PMLA. Simple filing of a charge sheet or taking some step again under simple thing like 420, a mere pure case of cheating, that could trigger off PMLA. Some matters of Trademark Act or Copyright Act are also part of the predicate offenses. So why should that be? I mean, unless there is something really in the nature of money laundering, where something is really harmful to the nation, that alone should lead to draconian powers, because the powers are very draconian. They can simply attach your assets, they can put you in jail. Yeah, I know a case where a person who's almost 70, 72 was in jail for a year.
Right. Sinadwa Datar, by refusing to create a peer review mechanism as it was done in Jacob Matthew, has the court missed an opportunity to build some sort of an institutional safety valve to protect the lawyers in the legal profession from such kind of a summoning culture?
I personally feel creating a peer review committee would have been counterproductive, would have been very difficult. First of all, what's the composition of the peer review committee? Are you going to have peer review committees at the state level, at the district level? Where do you go? So this is very good in theory, but it would have been very difficult to implement in practice, having a peer review committee. On the other hand, what the Supreme Court has done, and I think rightly, is that they've taken the existing law and added on some safeguards to those particular sections, like summons, for example. Section 94 of the BNSS says you can summon any person. Now they say you can't summon an advocate unless you get the permission, the approval of the.
Superintendent of police, yeah.
And further, that summons also is subject to a right of judicial review under 482. Now it's, I think, 528 of the BNSS. So these, similarly, they've also mentioned on digital evidence and other parts and things like that. So
Hmm.
they have, instead of creating a peer review committee, what is now done is more easily manageable and more efficacious, as far what I think. Of course, these are directions that have come hardly 2 weeks ago. I mean,
They need to pan out on the ground, yeah.
yeah, they have to pan out and see how they are implemented. If there is some difficulty in any, you can tweak it, modify it.
Uh, so the judgment, if you read it very closely, it's open in front of me. The judgment basically treats the lawyer's privilege as belonging to the client and not the advocate. Uh, how does that reshape the idea of professional independence for the bar?
Actually, there's no privilege for the advocate per se. What has happened is it's the client's privilege. That is, the advocate is not allowed to disclose something which is about his communication with the client. Privilege, if you see the section, it's the privilege of the client, and the advocate is protected because the client has got the privilege not to disclose what he communicated with his lawyer. That's a fundamental thing. So only when the lawyer participates in the crime or he is an accessory to the crime before it's committed. The proviso is very important. The illustrations are very important. Like they say, if you're going to commit forgery, if you've committed forgery and you engage me and then I advise you, then that is protected by privilege. But I can't tell Mr. Roy how to commit forgery and participate in that, then I'm not protected by privilege. So, and the privilege, the law of privilege is setting up for 100 years. There's so much of the nuances of privilege. There's the litigation privilege, non-litigation privilege, and so many things. But I think what the court has done is, in a way, correct interpretation of the law with additional safeguards.
Right. So the court, we were just speaking about this. The court has in this judgment said that, a permission or an approval of a superintendent of police would be required to send summons to a lawyer. Do you really see this as an effective filter, or this is just a procedural step which is perhaps would be open to misuse?
See, well, I'll speak from experience as a tax lawyer. In central excise earlier, you could demand duty for the last 12 months and you could go up to 5 years with the permission of the commissioner. The commissioner had to issue the notice if you're going for 5 years, thinking that if it's a senior officer, there'll be some kind of safeguard. But that really didn't work in practice because everything was invoking 5 years. Now,
Okay.
I don't know how the superintendent is going to work, but I think it's still a right step. So basically the SHO or the investigating officer, he can't just come and say that, Mr. Roy, come, Mr. Datar, come and appear before me. Give me this document, give me that document. So whatever summons he issues has to first get it is a filter, as you rightly put it, filter at superintendent. Now, how efficacious it is will be there, but I think it's still an important filter. And secondly, the superintendent is not a rubber stamp. He has to apply his mind and see whether the summons to the lawyer is in the teeth of Section 132 of the BSA. Is it rightly done? So, at the senior level of a superintendent, the application of mind by a senior officer, that definitely will be a filter in law. In practice, if they apply it, it will work very well. Further, the superintendent again is not the last one because, as I said, the superintendent's satisfaction is again subject to judicial review.
Right.
So I think this two-layer first layer filter and the filter being subject to judicial review will definitely be a huge protection to lawyers from this just arbitrary summons being issued by police officers and investigative agencies.
Senior Advocate Datar, this particular judgment allows production of documents and devices under the court supervision. Now we all know that with the advent of technology, etc., and especially in this era of digital, data files and overlapping client data and client files, how practical is this implementation of this safeguard?
Well, that's a real problem because if you take my laptop or my iPad, it'll have of any lawyer, it'll have large amounts of data which are subject to privacy of various clients. It may involve investigation of client X, but
Right,
data of A, B, C, D, E, F, G, who
right.
also will be subject to their thing. So now, by subjecting it to a court approval, maybe you can then point out that, look, this file, my laptop contains 260 files, only three files
Hmm.
are for the purpose of this case, provided
Right.
it satisfies other norms. So you
Right.
take the three files and don't touch the remaining 200 odd files which are not concerned with this case.
Okay.
Today, there is no safeguard. You can just take the iPad, you can take the laptop, download the entire hard disk, and there's no safeguard. Yeah.
Okay. So the one of the aspects of the judgment which has caused a lot of heartburn in the legal profession is the exclusion of the in-house counsels from the
Yes.
Section 132 bit. Um, how do you think, the corporate counsels or the in-house counsels would now navigate their way, especially when they are dealing with such, criminal processes or issues?
See, because of the judgment, they have now made it very clear that 132 doesn't apply to an in-house counsel. Now, what's an in-house counsel is not defined, but as we understand in general terms, he is the GC or the legal advisor or the legal counsel for a company or a group of companies. I personally feel that the privilege should have been extended to them also because the what is the client doing is consulting a legal professional.
Right.
He could be a lawyer practicing independently, or they could have an in-house counsel. Say, for example, a large group may have in-house counsel because the sheer volume of work that is required. And so they will have at their requirement a lawyer who's dedicated to them 24 by 7 because of the needs of the time. So I don't
Yes.
see why the privilege should not have been extended to them. Suppose the company has consulted its in-house counsel. He's not an employee. Even assuming he's an employee. The point is, if he's working as a lawyer and there's a consultation with him, then it will be should have been extended because in-house counsel are nothing but lawyers. But only thing they are lawyers. I mean, they deal with the legal issues of one particular client. Maybe that could have been extended.
Okay. Investigating agencies, as you know, Mr. Datar, have previously also withdrawn such summons which have been issued to lawyers and advocates,
Hmm.
often after public outrage. Does this judgment create enough deterrence for us, as to say, to prevent such overreach from happening in the near future?
I think it certainly does. I think it really does because of the directions given in the last paragraph and the requirement of getting a prior sanction or prior approval of the superintendent plus automatic judicial review under 482 of the old CRPC. Definitely it will create a deterrence. Now, what was someone which is issued to me cannot be issued now. It would have to go to these. I don't know how it's going to work out with the ED and others. This is in the case of a superintendent of police. There it could be the head of department or the director. So there will be some mechanism, and the director has to apply his mind. So there has to be a file note or a record
Right.
of reasons as to why you have asked a lawyer for some documents or for the communication.
Okay.
Isn't it?
Do you think, sir, that this judgment really restores the balance between investigative powers and professional privilege? So, for us to say, or does it still leave the bar, vulnerable to such summoning culture?
See, I think there's no restoring balance. The balance was maintained by the law. So Section 126 of the Evidence Act was there for 100 years. It was working well. There are a large body of cases which lays down what lines you cannot cross, what boundaries you cannot cross. So the law is very, very clear. Unfortunately, in the recent past, in the last 5, 10 years or so, or before that also, they started the practice of the investigating officer also asking the lawyer to disclose what the client said and so on in the course of their investigation. Now that was really a aberration, was a violation of the law. The court has merely put a stop to it. So I won't use the word balance. The court has now maintained the integrity of Section 132, maintained the integrity of the legal process of privilege, and said that if you want to breach it, you have the superintendent's approval. See, obviously, in an ideal situation, the investigating officer should know the limits of Section 126 of the Evidence Act or 132 of the Bharatiya Sakshya Adhinayam. Now, since the IO has gone beyond 132, and we're going beyond 32 because even the Supreme Court judgment ultimately quashes the
Right.
Gujarat. Yeah. Since they were crossing the limit, now the superintendent has put a check. So I think they have brought the law on even keel with an additional protection that if you're not going to apply it yourself, we will make sure that there is some safeguard for the lawyers and for the community. And this is protection is also for the client because the
Okay.
client's confidentiality also will not be breached because of these safeguards.
I have to ask you this, that there has been a lot of critique by legal experts of this judgment, wherein they have gone on to say that this judgment is nothing but a lost opportunity, and that the bench could have very well avoided taking so much cognizance of the issue if it was not laying down proper authoritative formal guidelines, and could have just dealt with the SLP, where the summons from Gujarat had to be quashed. What is your response to that?
See, I very frankly, when you say lost opportunities, you must tell me what, when the person criticizes the judgment, he must be able to specify that this is situation A, B, C, which the judgment has not dealt with, and that's why it's a lost opportunity. I have not heard or discussed with some people. Nobody has said what is a lost opportunity. There is some concern about in-house counsel, as you mentioned. There is some concern about the difference between a document and a communication. The section talks of communication. Now this judgment says documents don't get the privilege. Where do you draw the line between a document and a communication? There could be a lot of communication, like draft documents may be exchanged between the client and the thing. Now, those draft documents are not documents, they are part of communication. So, there are two, three areas which have to be still
Yeah.
clarified. But I won't characterize it as a judgment of lost opportunity. I would say much ado about nothing, something like that. I think no. It has discussed the law. It has said why it's not issuing guidelines. But as I said, it has still gone on to issue directions, which in my opinion are guidelines, which are mandatory.
So that was Senior Advocate Arvind Datar with us, one of the senior lawyers who was served with a summon from an investigating agency, saying that the judgment is indeed progressive by the Supreme Court of India. Thank you so much, Senior Advocate Datar, for being with us at the Bar and Benches
Thanks to
interview.
the bar and bench team. All the best to you.
Thank you, sir. Thank you so much, sir.